The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases will be submitted this morning. The first case that was scheduled, State versus Earl Booth Harris, has been continued to tomorrow at 1 o'clock. So the 3 cases that are submitted this morning are in re the 2018 Grand Jury of Dallas County, John Doe. The second case is State of Iowa versus Tony Doolin. And the third case is State of Iowa versus Jeffrey Meyer. Now the Meyer case is now submitted without an oral argument, and we'll hear the arguments in the Grand Jury of Dallas County.
May it please the court. Mr. Miller, I don't know whether this is a blessing or a curse, but this is the second time in a row I've been here when I've been moved up to number 1 to argue the case. Any lawyer knows that expert witnesses are essential to offer evidence to meet your burden of proof, or to offer evidence to combat attacks on causation. When it becomes reasonably certain an expert will give his or her professional opinion as a witness on a material matter in dispute, then his or her opinion becomes a factor in the case. The expert is no longer a consultant. Although there is no specific case in Iowa on this point, we believe that pretrial discovery rules gives this court some insight into this matter. And the district court judge, in taking plea negotiations and utilizing those discussions to establish a base for discovery in the grand jury, turned the rules on their head. We all know that when an expert witness is consulted, they reflect on the attorney's impressions, their conclusions, their opinions, the legal research they've done in the case, and also their theories. They are not discoverable.
Counsel, the district court, among other things, said, suggested that in the plea negotiations or preliminary discussions that you had indicated kind of the substance of the expert's proposed testimony, namely that instead of bruises caused by battering, it was a skin condition or some words to that effect. Although the district court's order is a little opaque, it looks like there was a finding of fact that indeed those statements were made to the prosecution. If so, isn't there a waiver problem here?
We don't think there's a waiver problem. First of all, under Rule 210, you cannot have plea discussions in an administrative process. You can't have it in a civil hearing. You can't have it in a criminal process. So there's a rule that gives the court some direction on that point. But second of all, the record needs to be complete. As you know, if you follow the chronology of this case was taking place between August 29th and September 6th. So within that time period, no call had been made to me, no call advising me that they are going to go in and talk to my expert, go in and subpoena my expert. So we were scrambling trying to put a defense together to quash this material. So consequently, there was no opportunity really to explore this, and she did not make a full record. She said, if I accept Mr. Schultz's comment on this point as true, then we're going to have to do it. But 2 lawyers were out there saying, well, Mr. Parrish has a conflict on another case in federal court, can't be here. So the question is, she didn't even make a full record as to what my comments might have been on that. And then she chose, Your Honor, to modify her order later saying, well, you can't have work product, but it was a little late because the court had granted the interlocutory appeal at that point.
Can I ask a question?
Sure.
What authority is there that this rule of discovery applies to a criminal case that the grand jury phase?
It does not. As a matter of fact, the directions, and we point that out in the brief, this is still at the preliminary stage. Only a criminal complaint is filed. So with only a criminal complaint being filed, the discovery rules don't apply. What they utilized was an agreement signed by John Doe's prior attorney, which said the discovery rules are in effect. The discovery rules don't even take effect until the actual grand jury indictment is returned or county attorney's information is on file. Otherwise, those rules don't come into effect. Additionally, as pointed out, when Mr. Schultz on January 18th filed the order to get the medical records, he does that with my consent and says, we're going to send you a copy of it. It was a shared discovery. The only time there's an unshared discovery is after the Attorney General's office comes in July 17th, where then they take upon themselves to start contacting the experts without calling counsel, subpoenaing witnesses without calling counsel. That's how they proceed, but yet they fall back on this idea, oh, we're all trying to cooperate. We're trying to get this exculpatory evidence into the grand jury.
That's the question I wanted to ask you. I think they relied on the Hall case for that exculpatory evidence, that the state's obligated to present exculpatory evidence as well. What I'm asking you is, are you saying that the spirit of that is only if it's the state's exculpatory evidence and that they can't tread into exculpatory evidence that might be in the hands of defense counsel?
Well, I think what you have to do is go back to the rule. There is a rule on it, too. The rule talks about if it's reachable within the grand jury, they can get access to it. But I think there's another problem. That's why I sent the Barrett case up that Justice McDonald was on in district court. It's kind of informative because he makes this statement that I've always advocated for, and that is exculpatory evidence should be looked at the advocate's eye. That's what this court has never addressed. But let me tell you something else about the case, Justice Christensen. Take a look at what the Attorney General says about exculpatory and what the special prosecutor says about exculpatory. Two things are in play here. The Attorney General, who only comes in the case in July, says, well, Mr. Parrish represents over and over again that it's exculpatory. Look at Mr. Schultz's statement. Mr. Schultz says, well, I'm not sure he used the word exculpatory. And also, the chronology is important because there have been several meetings on plea discussions taking place that's outlined by Mr. Schultz and myself, including a luncheon meeting that was discussed briefly. But in all of those discussions, Mr. Schultz did not say that as exculpatory, or I used the word exculpatory. So I think you have to go back to Justice McDonald's discussion that's really important to all of us out here. What is exculpatory? Who defines it? You know, you talk about it clearly in the cases that talk about the records, and the legislature then changes it. And I think Justice McDonald talks about, well, maybe we should talk about it and review it again. And he says, I'm not going to do it in this case. But it's, who defines exculpatory? The judge only gets to the issue of exculpatory when she decides to accept the Attorney General's representation that that's what I said. So I go back to this question. Why don't we complete the record on it? If you think that's an issue, complete the record. But I think the record is complete. I'm sorry.
Mr. Parrish, do you I want to clarify your argument a little bit. Are you contending that the grand jury doesn't have the power to subpoena a defense witness?
They do. An expert witness, no. They can.
So that's the distinction you're drawing,
is
it's a retained expert here versus a fact witness or an alibi witness.
Correct, but also it's important as to how they did it. The state in their brief argues this. They said, well, she only subpoenaed them because they wanted to present the whole picture. That's not what happened here. The state's brief gets it absolutely incorrect. She calls Dr. Railsback, who's always been a witness for the state. And that's how they know that she's a significant witness. They call her up. She says, lucky for us, she don't want to talk to him because she's worked for the state, so she understands that process. What happens next? She gets to court. She does an affidavit. In her affidavit, she says, well, I'm called by the prosecution. I don't talk. She says, then I'm going to subpoena you if you don't answer my question. It's August 29th. The same date she makes that call, the prosecution calls me driving back from Chicago to Des Moines, tells them we're going to convene a grand jury, but doesn't even tell me that she's going to call my witness at 11:35 in the morning. So when she calls my witness at 11:35, lucky for me, my witness calls me and says the prosecution has called me. The state in their brief says, well, this all started because we wanted to deliver everything that we thought had been discussed in those plea agreements to the court. That was not the reason. If you look at the date of the subpoena, she doesn't even issue the subpoena until the 30th, the next day. She didn't even serve her until the 31st. So the chronology,
Hypothetically, assuming that was the reason, one would expect maybe a courtesy of a phone call to you and to say, I would like to present anything that's exculpatory. Do you have any objection if I subpoena Dr. Railsback?
absolutely. And that's what you do in the civil cases, and we know that if you don't have the criminal rule, you look to the civil rule to see what's applicable.
Does it matter whether this expert was a consulting expert or a testifying expert?
It does.
And then what was
It does,
what
Your
was
Honor,
she?
Justice Appel, and this is what I think. If it's a consultant expert, you're sharing all your impressions with that person, your weaknesses of your case, your strengths of your case. But once you designate it, and you understand, obviously, you are better than I, that under the Iowa rules, you don't even have to make a disclosure. If I didn't do any discovery, I don't even have to list Dr. Railsback. I don't have to list a single witness. If I do no discovery, I can walk into court, I can present my expert witnesses, and nothing the state can do about it. They can do the same thing.
Okay, so
But it's
you're saying she was a consulting expert?
She was at that point because that's the only thing that's taken place at that point. Remember, we don't even have all the discovery.
So a decision hadn't been made whether she was a consulting expert or a testifying expert at this stage.
But she's an expert. Consulting or designated to be a witness is another way that you could set this expert up.
Had you made a reciprocal disclosure and designated her as a witness in a reciprocal disclosure?
We had not, Justice Mansfield, and technically under the rules, you don't really have to do that until the trial information is on file, and then you have about 40 days, then you designate it or you extend the time, and you want to be sure at that point that you want to use that witness.
So what is the harm in this sense? Setting aside the communication between the prosecutor and the witness, you have a subpoena. I think you'd concede that the grand jury can subpoena defense witnesses.
Not expert. I have not conceded that.
Oh, fair enough. But the witness can still assert any common law privileges or any other privilege in response to any questioning. As my understanding of the district court order, at least the second one, is there was a carve-out for a work product. So what is the harm?
Well, I knew that would be a question, but as a presumptive violation, first of all, and I don't think there needs to be a harm, but let's say there is a harm that we wanted to discuss this morning so other lawyers in the same situation could understand, or prosecutors or judges. This is the harm. You're going to have your expert witness sitting in a grand jury proceeding without the lawyer. They can frame the question any way they want to. Any grand juror, and that's one of the biggest dangers of grand jury, obviously, is that a grand juror asks a question that could be troublesome or create a problem. They can ask you what your lawyer is thinking. Did he say something else to you? If she carves out the work product, and it's important, again, on the chronology, she didn't really carve out the work exception till after she read my emails the night before, and the fact that these lawyers who were there covering the case were not intricately involved in the plea discussions. I would just say as a side note, I would stack my record of 40 years in this state as to what type of allegations I would make, and watch what Mr. Schultz says about my statements and what the Attorney General says about my statement. But I have 40 years of a record that this court has appealed, has reviewed, and I'm sure they would question those statements themselves. But to get back to the question, the harm is enormous. If your expert is sitting in a grand jury room without any opportunity to have the lawyer. Now, she can stop and come out and say, well, Ms. Parrish, how should I answer this? She was bright enough to do that. But again, this is an expert who's worked for the state for a number of years, so I would have some concerns of her going
I know
there.
grand jury practice in the state is fairly limited compared to federal practice. To what extent should we rely on the federal cases or, for example, the DOJ manual on grand jury proceedings?
I read the DOJ manual and the allegation that the state is making. I do more federal work than state work. My comment on that, they've never subpoenaed one of my experts to come in front of a grand jury. They said their idea is to present all the favorable evidence or in a kind of a global presentation. I mean, the rule might be beautiful, but in practice, it's quite different, and I think any other lawyer would say that who does a lot of federal work. To say that you want to do it, but if you're going to say that, say it in good faith. Say it in the terms of, how did this case originate? How did it get there? In this case, I don't think the argument is a good faith argument, considering how this arose. compare it to the federal system, yes, they say let's make a global presentation of all the evidence. In practice, is that actually done? I mean, you read the cases that come out of that system and you see that it's in practicality, it's a whole different application.
But the manual does indicate that the prosecutor should present exculpatory information or potentially exculpatory information.
If they know it. I think the rule says that they personally know it. The question is, what's personal? How do they know it, and under what circumstances? Obviously, I've been in situations where the prosecutor knew something personal, and we've challenged it. But the question is, if they personally know it, how do you define personal? You have to look at how that rule is actually applied across the board.
But in this case, I know you didn't have to make disclosures yet, and maybe you wouldn't have disclosed.
We would not have. I think it's
whatever communications you had, you disclosed the identity of a potentially exculpatory witness to the prosecutor, who now, if the prosecutor wants to present exculpatory information, should he or she ignore that?
They should ignore it because the plea discussions are not part of what that record should have been. Obviously, that objection wasn't made, but it should not have been part of that a record that the judge made. She should not rely on it. And if she is going to rely on it, she should give both sides an ample opportunity to respond. And I think she tried to cure that in her modified ruling, but unfortunately it was a little bit late because I think this court saw the seriousness of the problem and intervened. Thank you.
Mr. Parrish, thank you as well. Mr. Miller.
May it please the court, Mr. Parrish. My name is Zachary Miller, and I represent the state of Iowa. The district court made a fact finding in this case that the state was putting on exculpatory evidence by calling Dr. Linda Railsback, evidence that the state knew because Mr. Parrish told the state's prosecutors about it. And the court further found that Doe was attempting to prevent the grand jury from hearing exculpatory evidence, and I think that fact finding is essential in analyzing the subpoena question. The state could subpoena Railsback and allow the grand jury to hear it because Doe waived privilege by disclosing her opinion.
All right, let's talk about waiver first. We do have the rule that says if a plea discussion does not result in a plea of guilty, which was the status at this point in time, there was no deal, neither the plea discussion nor any, etc., shall be admissible. Now, how do you get around that? Because wasn't the state relying on the plea discussion in order to, was using that in court, was having that admitted in court in front of Judge Relf in order to pursue its waiver argument?
I think that the rule prevents the presentation of evidence at a trial before a jury.
It says any criminal or civil action. It doesn't say at trial.
My understanding is that's how the rule has been interpreted, but in any event...
Where have we said that?
I can't point you to a case right now, Your Honor, but I'd be happy to add supplemental filing after this argument. The rule on communication is you can't put forward what the attorneys have said, and that as an issue wasn't raised in terms of not allowing the judge to consider it at the hearing. The judge was entitled to consider that, and in any event, it would put the state in a real precarious position where it knows exculpatory evidence that it's been told.
Why is it that precarious? Because all trial counsel had to do was call Mr. Parrish and say, we're based on the plea discussions, I'm aware of Dr. Railsback. Do you have any problem if I have her subpoenaed to the grand jury?
Well, perhaps that would have been a better procedure, but I don't think that the rules demand it. The state, in fact, told Mr. Parrish about the grand jury proceeding. It didn't need to do that under the rules and under the state's cases. And it also discussed putting in evidence that Mr. Doe would have wanted to hear in the form of pictures that Mr. Parrish asked the state to put into evidence, and the state agreed. And I think that the state was concerned about disclosing all of the witnesses because the proceedings themselves are secret, and for that reason didn't disclose that. Again, the communicating privilege waives it, even if it's work product privilege, in a plea discussion. And so that information isn't protected anymore.
That just has never been my impression. I mean, if there's not a proffer, people can say things in plea discussions without having to walk into court and face those statements in front of a judge.
Well, What you're not allowed to admit is the actual statements by counsel. You're allowed to go and investigate what you've been told to determine the strength of the case.
Isn't it fairly common where the police would do subsequent investigation based on fact information learned during the course of plea negotiations? So the defendants identified potentially relevant witnesses that may support his or her defense or mitigate some degree of culpability. At least that's my experience, that there's a distinction between the actual plea negotiation and the underlying knowledge obtained during the course of that discussion.
That's exactly right, Your Honor, and that is part of what allows the police system to function. The state hears what the target has to say and goes and investigates it to determine the culpability. So if you tell the state there's these 3 people who saw I didn't do this crime, or we'll say this, the state can go investigate.
And I grant the dialogue between you and Justice McDonald. I think that's correct. But that isn't really what is at issue here. What's at issue is trying to create some kind of a waiver based on a statement, not using something that's said in plea negotiations as a basis to go and look for other evidence. And those things are different, aren't they?
Well, I think, Your Honor, that Doe number 1 is a case, it's out of the 11th Circuit, in which the defense disclosed to the prosecution during plea negotiations privileged information, and I believe it was work product privilege, and the court found that waives the privilege and allows the state to, or in that case the United States, to go and get that evidence and evaluate it and present it.
I want to ask you a question about that very case. In the Doe case out of the 11th Circuit, that was correspondence that the defense gave the prosecutor, am I correct?
I believe so, Your Honor.
Okay, and if so, then the later language says, disclosure of work product materials to an adversary waives work product privilege. Was there anything provided to you by either Mr. Parrish or his predecessor in the form of an actual document or a hard piece of evidence, or just words?
It was just the statements that Railsback would testify, or was her opinion.
Do you think that's different?
I don't think it does make a difference. I think what protects the privilege is that you don't disclose it, and by disclosing that information, whether it's via written communication or an oral statement, you've disclosed the privilege to your adversary, which waives that privilege. So I don't think that there is a distinction or a difference there that matters.
So a letter actually written by an expert, handed from a defense to a prosecutor, you have it in your hands, whereas the conversation going back and forth during plea agreements, isn't it sometimes just puffery by both sides saying this, saying that? Do you really feel you can go to the bank with what's said, more so than a letter?
I don't think that the state is obliged to believe everything that is represented during a plea discussion, but that's exactly why the state follows up on that, to try to determine culpability in making a charging decision or here presenting that evidence to the grand jury.
Are we going to have a chilling effect on plea negotiations if statements counsel makes during the course of those discussions results in a court-imposed waiver?
I don't think so. In fact, I think if the state is not allowed to go and investigate the factual representations made in plea discussions, even if it deals with privileged information, it could prevent the state from making informed charging decisions and reduce the likelihood of pleas if the information is in fact favorable to a target.
Is there a difference between the state following up and say the defense lawyer said this witness provides an alibi versus the state following up and contacting an opinion expert who's merely been a consulting expert at that point, not somebody disclosed for trial?
Well, I think that the difference is that if the privilege hadn't been waived, then it applies, and the expert can still, the grand jury proceedings claim it here. The rules provide for the district court to rule on the privilege, although I think that the district court has already done so. But for each question that might be asked by either the state or grand jurors, the doctor can claim privilege if she believes that it applies. Doe can prep the doctor before any testimony is given, and the court will resolve any kind of privilege question. So there's no harm to Doe here. No harm has happened in terms of discovering the defense. If, in fact, there is a defense of there's a skin condition, and that's going to be presented at trial, the state will, given the reciprocal discovery order, get that information. And if there's no such defense, then this is all irrelevant.
There hasn't been a reciprocal discovery order in this case because you're at the complaint. So, as Mr. Parrish said, he could walk in with 20 witnesses to say the same thing, and that's it, unless there is a reciprocal discovery order. But My bigger concern is, assuming you're right, there's a waiver as this one small issue, how do you protect Doe on all the other issues that may be protected by work product? I mean, you say the doctor could make those objections, but the doctor's not an attorney, and the doctor doesn't know how to protect it. That bothers me somewhat.
And I understand that concern, Your Honor, but if you read the affidavit of Railsback, it comports with what Ms. Timmons told the district court. She asked the Railsback whether or not, Mr. Parrish told me this is your opinion. Is that true? It was a yes or no question based on the information that had been disclosed. It wasn't a broad, open-ended, what do you think about, this in general, to try to get a bunch of information that wasn't privileged. She tried to make a very limited, specific request based only on what had been disclosed, and I don't think that there's any basis to think it'd be different.
But I could see the questioning going, well, you say it's a skin condition. Well, how do you determine a skin condition? What documents do you need to determine it's a skin condition? What type of tests do you need to determine it's a skin condition? And then you're getting into the way that Doe's attorney would go to present this exculpatory evidence, which creates a problem, and I don't know how you draw that line.
Well, I think what you could do is you could, before the hearing, perhaps prep your witness that this is what the ruling is, that you waived as to just the fact that you have an opinion about a skin condition, and direct her to claim privilege on any other question beyond that, which the court would then make a ruling on.
The basis of her opinion be subject to discovery?
I think it probably would, and that's under exotic botanicals out of this court, which is held that work product waiver doesn't apply to all of the subject matter of the waiver, just to the specific opinion disclosed or information that was actually disclosed, not to everything on that subject matter. So I think it probably would still apply, Your Honor.
But when you get the basis of an opinion, you're probably getting the way that Dr. Railsback told Mr. Parrish of how you prove this is a skin condition and not a skin condition, and what factors are necessary to get there. And it seems to me that, and how you would cross-examine the state's witnesses because of those underlying things. So I think you do sort of get into work product when you start going down there. That line.
Well, I don't know that any such questions would be asked the underlying bases. And again, the privilege claim can still be made and ruled if those questions are asked. And the court will decide them. And if they decide them contrary to Doe, we could, I guess, have an appeal on that issue. But that's just not what's presented here right now.
Mr. Miller, could the prosecutor in the grand jury proceeding just simply tell the grand jury that I've had discussions with defense counsel in this case? It's been revealed to me that there's a defense that would be supported by a doctor's testimony that this was a skin condition. And I would like you to consider that when you're determining whether to return an indictment. Would that be an adequate way to deal with the state's concern of getting all the information to the grand jury to make a fair judgment on whether to return an indictment?
I'm not sure under the rules if that's proper or not, if that would be considered the prosecutor testifying, and whether or not that might be improperly trying to influence a decision one way or the other. So I'm not exactly sure whether it's proper under the rules. I'm not aware of a case that decides that question.
But if you contacted Mr. Parrish ahead of time and said, I'd like to present to the grand jury that your doctor would say it's a skin condition, and he either okayed it or got an affidavit, that would take care of the problem. But no one talked to him.
Well, again, I think it's a little unfair to say no one talked to him at all. It's true about this particular subpoena, but he did have notice, and they filed the motion to quash. And they were disclosed. The proceedings at all don't have to be disclosed. So you don't, even more strongly have to disclose the witnesses you're going to put on before the proceeding if you don't even have to tell that the proceeding's happening.
But he didn't have to disclose what his witness said. I think he was dealing in good faith with you guys, and it sort of backfired on him.
Well, I completely agree that he didn't have to disclose that. That was a choice to try to influence the charging decision to get a less, possibly resolve the case completely in his client's favor. That's a tactical or strategic decision about the case, and it waived privilege and allowed the state to put that evidence on.
Would you agree that without a waiver that it would be improper for a prosecutor to contact ex parte a consulting expert who has not been identified as a testifying witness?
I think it would, and I think it would also be somewhat difficult for the state to know who a consulting expert is, at least in most cases, absent the attorney telling the state who the consulting expert is. That is pretty rare and usually doesn't happen for the exact reason you don't want the other side to know your consulting expert, because you don't want to waive privilege and allow them to peer into those communications you've had. So the first line of protection is don't disclose your consulting experts. In any event,
I have a question, please. We were exploring earlier the obligation to present exculpatory evidence, and there's at least some authority to that extent. But if Mr. Parrish was very clear that he did not want this expert to appear, why didn't you just say, okay? I mean, your duty to present exculpatory evidence certainly would have been relieved, would it not, by a defense counsel objecting to the admission of her testimony to the grand jury?
I actually don't think it would have, Your Honor, because I think that the state has a duty to justice in general and to make sure that the grand jury hears that information. I don't think the state has to risk an ethical violation. And I agree with you, the law is not clear, but certainly there's authority to suggest that it's best practices, if not actually required, to present exculpatory evidence. And so I don't think that the target gets to choose what the state puts before the grand jury, including exculpatory evidence. Just briefly, I'd like to touch on the disqualification issue. Ms. Timmons is no longer with the Attorney General. She's the chief administrative law judge in the state, and so I believe that question is moot. She's not going to participate in this case further. And for the reasons stated in the brief and discussed here, the state would ask that you affirm the district court order in all respects. Thank you.
Mr. Miller, thank you as well. Mr. Parrish, you may present your rebuttal.
Thank you. I would agree with Mr. Miller on that point. That issue is moot. On the other points, I have a strong disagreement. Justice Christensen, you asked a question about writing and statements. There's a total difference. Matter of fact, in that 11th Circuit case, they talk about it. Had I shared an opinion, had I had one at that point and shared it with them, I think that may be fair game. I'm not sure I wouldn't have resisted it. Would that have been fair game as to that opinion? Could they have presented it? But I think under the rules of the grand jury, they may have had problems doing that.
You're saying you thought it would have been fair game if perhaps what you said was in the form of a letter?
If I had given them an opinion and shared it with them. That also may go to the waiver issue, too. But plea discussions, the puffery, the back and forth, the taking place over 8 months, numerous issues involved, a prosecutor involved as the...
Let's assume the doctor here wasn't a retained expert, but was a second doctor of the child.
There was a second doctor here, too.
Or a third.
Right.
A fact witness,
which they didn't even bring up in the discussions, right.
So, and would it be a different case in your view if you had disclosed to the state there was a third doctor, and this third doctor would conclude that this was a medical condition versus evidence of abuse? Is the state allowed at that point to subpoena the witness and investigate further?
I don't think under any circumstances, if that was a consulting person as a treating doctor, as you know, they got the treating records that talked about this, even though they represented to the court. It didn't show any problems. Quite frankly, the medical records showed that there were some problems. So the question is, if there's a third doctor, I make that disclosure, would that person be an expert, if I'm allowed to ask that question?
Could that person be subpoenaed?
Oh, if I designate them as an expert?
Or let's assume the state's proceeding how it usually would by trial information.
Right.
Would you expect an investigating officer to at least interview the doctor?
I don't think we will have a question with the interviews. And if trial information is filed, Justice McDonald, everything is open at that point if we went through discovery, through the pretrial rules. That's why I said there is some semblance of order to how this is done.
But investigating prior to the trial information being filed as a basis to establish probable cause for the TI.
That might be a problem. That might be something that we are aware of it that we may object to. I want to address another issue that is significant for this court, and that is plea discussions. Plea discussions are the heartbeat of the system. If you can't go into a plea discussion with a prosecutor with the rule in place that it cannot be shared, you will end plea discussions in the state. There would be no more. Why would they? And then they say that, I don't know where the validity of the argument comes from, or the logic of the argument comes from, when people don't disclose that. When people sit down in plea discussions, they have full disclosures. I don't care whether you're in the federal system or the state system. That's what you're there for, to talk about trying to resolve a case. So
well,
you cut
but
the heartbeat out.
The argument is, I think, somewhat more limited, and that is this. I think the state is suggesting in plea negotiations, if there is a waiver of privilege, and you listen, I understand the dispute of whether there's a waiver or not.
Correct.
But in plea discussions, if there is a waiver of privilege with respect to a certain fact, the state's free to pursue that. So the rule the state seeks is defense counsel can engage in plea bargain back and forth, offer to plead to X, Y, and Z, argue the evidence, and so forth and so on. But in plea negotiations, counsel has to be careful not to waive privileges. That's the rule they seek, I think.
It seems like that's the rule, but it's probably somewhere up in the air that doesn't deal with reality. And I think theoretically you can have a rule like that, but then you should exchange those waivers. You should let them know. Both sides should outline what they were going. For instance, should I walk in and say, well, Judge, as part of the plea agreement, the Attorney General walked in when I'm sitting down, pointed her finger at me and said, if I don't have a deal by 5 o'clock this afternoon, your client's going to be indicted on a felony that's mandatory? I mean, what does that have to do with any issue of the discussion? The discussion is confidential by rule, is to be protected. Disclosures are to be made between those parties. And the rule that's in existence, Rule 210, if you want to change it, yes, but this is not the case to change it in, because you don't have the chronology to establish that.
Or if they come into discussions and say something like, well, we'll talk to you because we think the person who's really culpable is Mr. X, and Mr. X was the ringleader. And if you wanted to try to use that statement, that would be challenging, right?
It would be, absolutely. Your Honors, thank you so much, and it's always an honor to appear before this court.
Mr. Parrish, thank you as well. Mr. Miller, thank you again. The case of In re, the 2018 Grand Jury of Dallas County, John Doe, is now then submitted, and we'll next hear the case State versus Doolin.